Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In this trial, judges, prosecutors, defense are not lawyers, but us, the community. In this trial, we say what we think, but we think what we say before we say it. Currently, the crime on indictment against the criminal justice system is wrongful convictions. That is when an innocent person is convicted of a crime they did not commit. Our opening note so far has looked into possible causes of wrongful convictions, current areas of debate in relation to reliability of trial evidence, transparency into investigations and prosecutions, crisis with legal representation funding. We have looked at how we currently treat innocent claims in the Court of Appeal. We will aim at concluding our opening note today and start calling upon our expert witnesses from our next video. So please be sure to subscribe and hit the notification bell so that you are notified when our next video is out. Today we will focus on private prosecutions and particularly on two issues. Is the recent increase of private prosecutions a sign of a criminal justice system unable to cope, and individuals or organizations genuinely trying to bridge the gap, or an attempt to create a parallel system of justice at the service of powerful organizations, charities, regulatory bodies, Machiavellian agendas? And do the new rules introduced by the Criminal Procedures Rules Statutory Instrument 2022-815, which came into effect on the 3rd of October 2022, render private prosecutions safer? Let's try to address the first issue. Some say that historical sense is what makes us humans. However, it seems as though us humans do not learn from history. When it comes to prosecutorial independence, we don't have to look too far back in history. Up to the 19th century, in fact, prosecutions in England and Wales were brought by the victims themselves. You don't have to use a great degree of imagination to know how this could have easily led to injustices. At the end of the 19th century and at the beginning of the 20th, gradually the police took charge of prosecutions. The police was therefore both investigator and prosecutor in most of the prosecutions brought at the time. With only a limited number of cases of importance and difficulties, left to the Director of Public Prosecutions, an institution which was created by the Prosecution of Offence Act 1879. A series of catastrophic cases in the 60s and 70s, which highlighted a very sorry state of affairs, directly descending by the fact that the police was both the investigator and the prosecutor, ultimately led to a criminal justice system both oppressive and unfair. Prosecutorial independence, both from investigators and victims, constitutes the underpinning principle for a fair and just criminal justice system. The CPS was established under the Prosecution of Offences Act 1985, following the findings of the Royal Commission on Criminal Procedure, chaired by Sir Phillips, which were published in 1981. The introduction of the CPS in 1986 was in response to criticisms of prosecutions which were deemed to lack independence and transparency, given that alleged criminality was both investigated and prosecuted by the police. The then Home Secretary Leon Brittan explained that the creation of the CPS reflects the principle that those responsible for investigations of the offence should not also be responsible for the conduct of the prosecution. The same principle inspired the recommendations made by the Gower-Hammond report in December 2000 and the Butterfield report in July 2003 in relation to prosecutions conducted by the then Her Majesty Customs and Excise. The SFO, the Serious Fraud Office, created around the same time as the CPS, was the only exception to that model, as it was structured on the Roskill model, in which prosecutors and investigators worked together from the outset of a case. The departure from a truly independent model was justified by the complexity of fraud cases and the advantages which an early cooperation of fraud specialist lawyers and fraud specialist officers would bring to those cases. In the last decade, the CPS seemed to have adopted the hybrid model too in most complex cases, as it now becomes involved in the early stage of an investigation in those more complex cases. However close is the collaboration between investigators and prosecutors, and whatever your views are on the current state of public prosecutions, one thing is certain, that both the SFO and the CPS are subject to inspections by the Her Majesty Inspectorate, subject to judicial review, and directly subject to scrutiny by parliamentarians, by media, and therefore the public. And most importantly, they're bound by a code of conduct. Prosecutorial independence from both victims and investigators was ultimately what inspired the conclusions and recommendations made by the Phillips Royal Commission. So how did we find ourselves in 2020 rediscussing these issues again? Though prosecutorial independence was deemed necessary and the basis for a fair criminal justice system, private prosecutions were, however, not completely discounted by the Phillips Report Commission. And provision was made in the same Prosecution of Offence Act 1985 at Section 6 that nothing in this part shall preclude any person from instituting any criminal proceedings or conducting any criminal proceedings to which the director's duty to take over the conduct of proceedings does not apply. This was on the basis of safeguarding individuals against public prosecution inertia, and as such, indeed, this is one that us private individuals will wish to treasure and retain. In 2019, the finding of a civil court that the private prosecutions of several postmasters and postmistresses by the Post Office amounted to an abuse of process, as the Post Office had failed to disclose flows in its accounting system and also to pursue all reasonable lines of inquiry during its investigation, led the CCRC to concerns over the appropriateness of an organisation prosecuting a case where that organisation is also the victim and investigators of the alleged criminality, calling into question whether the existing safeguards around private prosecutions are sufficient. We did discuss the post office case in a dedicated video previously. If you missed it, you can watch it by clicking the link somewhere here on the screen. Also, give us a thumb up if you like what we do, and leave a comment below to let us know your views. And consider subscribing to allow this channel to grow. So, as we were saying, the CCRC concerns were brought to the Justice Select Committee for discussion. The committee found that the Post Office was not the only powerful organisation who privately prosecuted. In fact, in the last decade, private prosecutions have proliferated. These were not prosecutions brought by individuals as a result of state inertia, but rather brought by powerful organizations who in most cases are the investigators, the prosecutors, the victims, and who have other interests at stake. Surely the most appropriate forum of these types of disputes should be civil litigation, as they tend to serve not the general public interest and safety, but rather the agendas or commercial interests of elite groups. However, civil litigations are expensive and convoluted. The truth is that the cost of private prosecutions, whether successful or unsuccessful, are recoverable from the taxpayers' central funds. So the inertia of the public prosecutors due to fund restriction is only apparent, as private prosecutions do still constitute a burden on the taxpayer's purse, with the added expense of private rates being applied rather than the much lower legal aid rates. One can see how it did not take too long for many law firms to advertise the win-win situation and the advantages of private prosecutions over civil litigations. In 2019-2020, there were 276 cost orders awarded to private prosecutions, 219 in the Magistrates' Court and 57 in the Crown Court, which resulted in the payments of $1,169,000 and $11,118,000 respectively. Each private prosecution in the Magistrates' Court cost an average of $5,338, and each private prosecution in the Crown Court cost an average of $195,053. So somehow we found ourselves again, 40 years later, discussing the issue private prosecutions versus public prosecutions. These matters were taken into account by the Justice Select Committee, which in its 9th report made a series of recommendations as follows. The government should strengthen the safeguards that regulate private prosecutions to ensure that any organisation that conducts a substantial number of prosecutions is subject to the same regulatory standards and expectations of accountability and transparency as public prosecutors. The Justice Select Committee says we recommend that the government would consider enacting a binding code of standards enforced by a regulator that applies to all private prosecutors and investigators. We recommend that HMCTs, that's the courts, establish a central register of all private prosecutions in England and Wales. The committee recommends that the courts should ensure that the CPS is notified when a private prosecution is initiated, the notification process should be integrated into the structure of Central Register of Private Prosecutions. We agree that every defendant who is privately prosecuted should be informed of his or her right to seek a review from the CPS. We recommend that this change be implemented by a change to the criminal procedure rules. In situations where the police are involved in a private prosecution and the role of the magistrate is therefore circumvented, it will be especially important that the defendant is notified of his or her right to request a review of the prosecution. We recommend that in such a scenario, this should be a duty upon the police to inform the defendant that they are to be prosecuted by a body other than the CPS and that they have a right to request a review. There is a strong case that organizations which bring significant numbers of private prosecutions should be subject to inspections. If an organization is found to be misusing the power to bring private prosecutions, then the body responsible for inspecting all prosecutors and enforcing the code, be it the CPS, the HMCPSI, or another public body, should be able to remove the right of an organization to bring prosecution or to require them to obtain consent from the Attorney General or the DPP before they initiate a prosecution. It is incumbent, the Select Committee says, on the government to ensure that the rise in number of private prosecutions does not result in the development of a parallel system where the public interest, accountability, and transparency are secondary to private interests. The government response to this report was the introduction of the Criminal Procedure Amendment No. 2 rules, which came into effect on the 3rd of October 2022. These rules essentially amended Part 7 and Part 45 of the Criminal Procedure Rules 2020. Part 7 of the Criminal Procedure Rules 2020 has now been amended and provides for the summon to identify who the prosecutor is, if the prosecutor is not a public authority. Part 7 now also includes specific scenarios in which the Magistrates' Court can refuse to issue a summon. At discretion that the Magistrates' Court had prior to this change in any event, though some limited case laws seem to have put this discretion into discussion. Some of the scenarios in which the Magistrates' Court can refuse to issue a summon are, for example, whether the prosecutor fails to disclose all the information that is material to what the court must decide, or whether the prosecutor's dominant motive would render the prosecution an abuse of process of the court. It is unclear, however, how in practice the Magistrates' Court is going to find out at this early stage of the proceedings when the prosecutor fails to disclose all the information material to what the court must decide, or what the prosecutor's dominant motive for the prosecution is, particularly when in most cases this process is undertaken ex parte, i.e. without the presence of the suspect. Arguably, the suspect is the most likely person to know whether there has been material information suppressed or what the real motive for a prosecution against them is. Part 45 in relation to court orders has also been amended mainly to request further information in relation to private prosecutors' costs when requesting a court order, and confirms that a court can refuse such payment whether such information has not been provided. So overall, the government declined the imposition of a binding code for private prosecutors, and decline to subject those organizations with a significant number of prosecutions to the scrutiny of any type of inspection. I am puzzled as to how these measures could be said to be capable of enhancing safeguards of private prosecutions in cases similar to those involving hundreds of innocent postmasters or postmistresses at the hand of the post office. Whilst we may argue that this more thorough approach and the further request of the private prosecutors to justify a summons and a request for detailed cost information in relation to cost orders are in principle capable of mitigating the number of private prosecutions, in our view, the only private prosecutions which are likely to be affected by these new measures would unsurprisingly be the genuine private prosecutions brought by private individuals who genuinely have been let down by the state. For example, the old lady who has been deprived of her entire pension savings by a callous fraudster that the police is not interested in pursuing, and who would have contacted a reputable private firm which will charge her private rates. And rightly so. Why should the law firm pay for the state inertia? But she will only be able to recover a cost at a legal aid rate. The rules, in our view, are not capable of discouraging powerful organizations whose sole scope is to exercise power or misuse the justice system, and who have in-house lawyers and an entire department dedicated to this purpose. Surely the most appropriate actions in view of the history and findings that prosecutorial independence is at the core of a just and fair criminal justice system should have led the government to make private prosecutions subject, one, to prove that there have been an effective inertia on the part of the public authority prior to institute a prosecution, and two, that the private prosecutors should be subject to a parallel mandatory binding code akin to those to which public prosecutors are subject. And if the private prosecutors reaches a certain number of private prosecutions, should be subject to appropriate and regular inspection and scrutiny. In our view, the Justice Committee was correct in concluding that this is the only way to ensure the public interest, accountability and transparency do not become secondary to private interests. We are interested in your thoughts on private prosecutions. Let us know what you think in the comments below. This concludes our opening note. In our next video, we will start by calling upon our expert witnesses. I would like to clarify, though, that there are other issues that have not been included in this opening note. For example, are inaccurate media reports and social media trial sub judice, i.e. trial whilst the trial is ongoing, which are not allowed, but we know they do take place anyway and are not routinely enforced, possible contributing factors of miscarriages of justice? And is there a scope for reform of our jury system? In particular, should juries provide reasoning for their verdicts? And is the majority ruling really in line with the criminal standard of proof of beyond reasonable doubt, or in other words, being sure? We have put these issues into a community poll exercise, which we'll bring to you very soon. Though these have not been included in our opening note, we will seek to address them in due course. If you are an expert in this field and want to help us in starting the debate in these issues, please do get in contact with us. The community wants to hear from you. And if you like what we do, consider subscribing to help us grow this channel so that we can invite prominent experts engaged in this debate to keep us up to date and to elucidate some of the most problematic issues involved. And of course, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. We look forward to usher you as we sit and rise in this unique trial.